Thank you, Claude, for that introduction. Now focusing on these 11 years that I need to go through in the next 25 minutes. What I intend doing is basically giving a very brief introduction on the directive and where we started, moving to reforms which happened even pre-2021, principally 2 of them, which we'll come to later, and then I will be focusing mostly on the Commission proposal, the proposal for reform of the AIFMD. And in this third part of my presentation, I will be skimming through 5 main points, 5 main proposals for reform, without going too much into detail on a number of them, because you will have sessions later on with Manfred right after mine on loan origination, delegation and substance, and tomorrow you will have a session on the depository passport and the depository mechanisms which are being proposed in the reform, and there will also be a whole session on sustainability. So the idea of my presentation today is more to set the scene for the detail which you will be going into later on today and tomorrow. So starting off with the introduction, the AIFMD, as we know, is a European Union-wide regulatory, provides for a European Union-wide regulatory framework, and it was introduced and implemented in 2013. Well, introduced in 2011, really, but implemented, it came into force in July of 2013. It sets out rules for fund managers around a number of different aspects as to how those fund managers should be operating in relation to their internal organizational requirements, the way in which they are marketing the funds which they are managing, and the manner in which they are raising private capital. And there it goes into quite some detail on remuneration policies which need to be set out and established by the fund manager, the manner in which the fund manager is monitoring the risk of its investments through the funds that it is managing, several reporting requirements, and more recently there is a sustainability slant also given to this directive, principally relating to the disclosure mechanisms. Although the directive does not regulate as such the fund, so the Alternative Investment Fund, the AIF, but it is a directive regulating the fund manager, the AIFM. On the other hand, there are a number of rules in the directive itself, particularly in relation to 2 points, really: the manner in which the manager is managing that fund and the disclosures which that manager needs to make in the fund documentation to investors, and secondly, even the manner in which the depository functions and what role the depository plays in monitoring, safekeeping, and generally doing all that is required of him in terms of the directive, which in an indirect manner the directive is also impacting quite heavily onto the fund itself. The main aim of the names of the directive were always, as these are underlying principles of most, if not all, EU legislation, which is consumer protection, so the protection of investors by introducing stricter compliance around how and what information is disclosed, and the removal of or an attempted removal of some of the systemic risks which funds of a certain size can pose to the EU financial system, to the stability of the EU financial system, which experienced which went through a rough patch during the financial crisis from 2008 onwards for a few years. And in fact, as Claude pointed out previously, this directive was one of the responses to the financial crisis. So insofar as the timeline of the directive is concerned, as we're saying, the AIFMD came into force in 2011. It was implemented, though, in 2013, or it should have been implemented in 2013. Most EU member states did so by the deadline. Some didn't and implemented it much later. But those were the exception, not the rule. In 2017, a review clause in the directive should have been triggered, triggering off really the revisiting of the directive, and this should have started in July 2017 for a number of reasons. This didn't happen, and the review really started with a report commissioned to KPMG, which was brought in to assess the directive against principles of effectiveness, efficiency, coherence, relevance, and added value. The report was published by KPMG in January of 2019. We'll come later now, we'll pick on what happened after that, because a number of different steps were taken by ESMA, by the Commission, and more recently, until yesterday, documents kept on being issued by the European Parliament, just to bring you up to speed as much as I can on the ether so far of the process. However, going back a step and going through what occurred prior to the 2021 publication of the reform proposal. So as a first step, we had, even at inception since 2013, we had a bit of an issue around what is pre-marketing. So one of the thorny issues on which us lawyers were being asked to issue legal opinions and to give advice, but we were sometimes a bit lost in view of the diverging interpretations of the rules by national regulators as to what constituted the activity of marketing of a fund. Now, this was addressed eventually through legislative intervention. Basically, new EU rules were introduced regulating the pre-marketing of AIFs, which were published in July of 2019 and came into force in August of 2021. So what was pre-marketing before the issuance of the rules was a matter of interpretation. Now, the pre-marketing is really the promotional activity of a fund manager which that fund manager is undertaking with respect to a fund that falls short of marketing under the AIFMD. So a step which happens before the fund is effectively marketing. At the time, there was no uniform position across the EU, so we had some member states, such as the UK at the time, taking a very flexible and open approach. I remember where clients were being told that the distribution of a red herring prospectus constituted pre-marketing, and hence wouldn't have attracted any form of regulation at that moment in time, whereas other member states were taking a much more restrictive approach that effectively prohibited pre-marketing. So it was either marketing or not. And of course, the big difference is that once you market, you are subject to all the rules arising from the AIFMD. The issue was addressed by setting out a definition of pre-marketing and by regulating on a pan-European basis what the fund managers can and cannot do as part of these pre-marketing activities. This was defined as being limited to the provision of information on investment strategies or investment ideas. There could be other fund-related information, such as the proposed terms or structure of the fund, which, again, this remains subject to a little bit of interpretation as to what detail can investors be given in the pre-marketing stage. The effect of these rules was the inability to rely on reverse solicitation for a period of 18 months following the start of this pre-marketing campaign. The AIFMs had to notify their home regulator of their pre-marketing activities within 2 weeks. The fund managers had to ensure that these activities were adequately documented, and the rules obliged EU member states to permit fund managers that are full-scope EU AIFMs for AIFMD purposes to undertake pre-marketing. So there was no further discussion and debate once these rules were issued as to whether pre-marketing was allowed or not. The next initiative related to the SFDR, so the sustainability factors which were introduced as a response to the approach taken by a number of fund managers which were tackling ESG risks at the level of their investee companies and drafting ESG action plans and purportedly promoting investment strategies which were in line with ESG principles without any real regulation. And in fact, questions were being raised as to the veracity of the relevant characteristics promoted by such funds. Are these funds ESG compliant or not? I mean, how can they be ESG compliant if there is no real ESG set of rules or set of standards which they can comply which they can comply with? And at the end of it, would this amount to a manner in which one could raise capital and attract investors without really being compliant with any particular set of rules? And this was the backdrop to the introduction of E-Regulation 2019-2088 on sustainability-related disclosures in the financial services sector, also known as SFDR. This regulation basically harmonized the rules for the disclosure of ESG information by fund managers. Once this regulation was issued, AIFMs were required to account for sustainability risks and factors as part of their ordinary course of duties, and reporting obligations arose towards investors, both at the management company level and at the level of the product. So these sustainability risks and factors had to be considered both at the management company level and at product level. As a result of SFDR, AIFMs are required to consider if they want to basically promote their fund as ESG compliant, as tackling ESG risks, and as well as integrate in their investment decisions and management processes relevant sustainability risks and the relevant principal adverse impacts of their investments on sustainability factors. So there are two elements here which need to be considered: the relevant sustainability risk and the relevant principal adverse impact of their investment. So on sustainability factors. So just as an example, and I found this in my research in one of the various publications which came out, I think it's one of the best examples I've encountered. Say the distinction between these two concepts, because once you read them, one doesn't really appreciate perhaps the difference between the relevant sustainability risks and the relevant principal adverse impacts of their investments or sustainability factors, these two elements. So coming to the first element, let's say a fund manager is considering to make an investment through the fund, of course, in a coal plant, which is producing electricity. So the first aspect would be, what are the relevant sustainability risks? And the relevant sustainability risks which that fund manager would need to consider would be water management by this coal plant, the use of child labor, appropriately health and safety policies, governance in the plants, etc. So generally speaking, how is this coal plant being managed, and what risks are arising from the way in which this coal plant is being managed across the board at a 360-degree level. On the other hand, it would also need to be conscious of the sustainability factors, in the sense, would an investment in such a business also cause principal adverse impact on ESG factors? In this case, mainly the environmental one, since it is a coal plant, and as we know, coal might not be the cleanest form of energy, of material that one could use. And balancing out these two factors and then disclosing to investors how these two factors are being considered in the investments which that fund manager is making is one of the hallmarks of this regulation. So moving on to the reform proposal. So the reform proposal, we really and truly started off by a letter sent by ESMA as required in terms of the directive itself on the 18th August of 2020 to the Commission, outlining areas of the AIFMD which could be improved. It then proceeded on the 22nd of October of 2020 with the European Commission launching a consultation on the review of the AIFMD. 29 January 2021, so just a quarter, 3 months later, feedback was received from interested parties, and this was required to be submitted, as we were saying, by the 29th of January. On the 25th November of 2021, then, this is one of the principal dates, the Commission published this proposal to amend the AIFMD. And well, finally, not really finally, because the ETA is well, we're around halfway there, is that on the 24th of March of 2022, the deadline expired for submission of feedback to the proposal. Now, at this moment in time, the status is that the trialogue process needs to commence soon. There is the European Parliament, which at the moment, I believe a report was issued yesterday. I think it's at the end of its first reading. I stand to be corrected here. And then it will move, of course, to also consideration by Council. So again, going back to the main aim of the directive when it was issued in 2011, it was issued in the wake of a global financial crisis to achieve coherent supervision and management of risks of AIFs. Article 69 of the directive called for a review of its application. And in this context, as we're saying, the European Commission presented its report and a detailed assessment to the European Parliament and the Council of the EU. The back-to-back evaluation contained in the Commission impact assessment on the directive found that the directive was largely achieving its objectives, which were saying investor protection, disclosure to investors. The main objectives of the directives were largely being achieved. However, it could benefit from some improvements in areas that, of course, 10 years ago might not have been sufficiently addressed, or that which would have evolved considerably since then. It was on this basis that the Commission, and against this backdrop, also adopted a new Capital Markets Union Action Plan in September of 2020. So the completion of the CMU is one of the priorities, as you know, of the European Union at this moment in time, in order to support economic recovery across all fronts, and to tackle the challenges which the European Union is facing in this moment. So it was against all this backdrop and the improvements which were being suggested that the reform proposal was issued. And the reform proposal, even if you look at the title, it relates to delegation arrangements, liquidity risk management, supervisory reporting, provision of depository and custody services, and loan origination by AIFs. This is what is referred to as a refit initiative, so a regulatory fitness and performance as part of the regulatory fitness and performance program initiative of the Commission. Going back to the ESMA letter, I'm not going to go through these because it will take us hours. You're free to read the ESMA letter. The ESMA letter highlighted in all, well, I could identify 19 points which the ESMA letter had suggested should be looked into by the Commission in order for refinement or detail. Not all these were taken up by the Commission, and we're going to go into those now, which were really then taken up by the Commission, and on the basis of which the Commission proceeded to issue its proposal. This proposal was preceded by a consultation, as we're saying, and the consultation had really 6 pillars, which were an analysis asking feedback on analysis of the directive on the utility of the passports, the scope of the license, whether it should be extended to smaller fund managers, the adequacy and effective of obligations of AIF firms acquiring control of non-listed entities, financial stability generally as to how this directive was helping in achieving that objective, the integration of sustainability risks, which we were referring to previously, and a more coherent approach in the treatment of UCITS, because really and truly, even when one looks at the proposal is also making some changes is also proposing some amendments to the UCITS directive in order for as much as possible the two directives to be aligned. There were proposals in the past on a single license for AIFMs and UCITS managers. However, it looks like the approach taken so far is that the two directives will remain separate, but as much as possible, with obvious exceptions like loan origination can't be provided for in the UCITS directive because it jars with the whole concept of a UCITS. With these exceptions, as much as possible, there will be some form of cohesion between the two directives. So picking on the 5 points, and I can add one more maybe. These 5 points which form part of the reform proposal are loan origination, clarity on the requirements of delegation, and with that I would also link substance, improving the supply of depository services in smaller markets, harmonization of liquidity management tools across the union, and improving level of data gathered through regulatory reporting. I think if we were to look at these 5 points, starting off with the first 3, all these 3, as I was saying previously, are going to be tackled by other speakers and by other panels during this conference. So I will just really touch upon just a few details on each, just to say that I've kind of set the scene. So loan origination is now being proposed as an activity to be added to Annex 1 to the list of AIFM activities, which is the activity of originating loans. And also there's also another activity, the servicing of securitization special purpose entities. There is no detailed definition in the proposal as to what activities may be included within originating loans and whether this would also extend only to the initial legal lender of record. However, this is detail which one would expect to see going forward arising or being clarified. The result of this amendment is that a fund manager in one member state can utilize the management passport to manage a fund, an AIF, in another member state that engages in loan origination. However, there is no passport for the loan origination or loan originating fund itself. So you could have different member states regulating loan origination in different ways. There are also thresholds established, which Manfred will surely go into, on the risk management of the manner in which and the thresholds which need to be applied when a fund is originating loans. Moving on to the next one, which is delegation. So here, as you probably know, there is quite a chunk of AIFMs in the European Union which delegate either the portfolio or the risk management of the funds that they manage. You can't delegate both, because that means that the AIFM is a letterbox entity. However, one of these, either the risk or the portfolio management, at least in my experience as a practitioner, I have seen being invariably delegated to third parties. These third parties could even be members of the same group of companies as the AIFM, so it doesn't need to be, and actually they are most of the time, third parties being affiliates or members of the same group of companies. What the proposal is trying to achieve here is that a notification process is being introduced where the AIFM delegates more portfolio or risk management than it retains. There is no really a definition of what is more, and as you will appreciate, portfolio or risk management, you can't really pin it down to a percentage. So if I delegate 51% of my portfolio or risk management, am I delegating more? Which means then that I would have to notify my national competent authority, which would then in turn be required to notify the European Securities and Markets Authority on an annual basis. So this is probably something which might have to be clarified going forward. Linked to delegation, there are also substance requirements which are being proposed, which really, I must say, state the obvious, because really and truly what these substance requirements are setting out is that the business of the AIFM needs to be managed by 2 full-time employees. Or if they're not employed full-time, they are committed full-time to conducting the business of the fund manager, and they are resident in the EU. So the way I read it, at least, the proposal is not requiring these people to actually be in the same country of domicile as the fund manager, but they would have to be resident in the EU, wherever that is. Again, further detail will probably you will probably have further detail on both substance and delegation in Manfred's session right after mine. Moving to the third point in the proposal, which are the depository services. So the rule at the moment in the directive is that the depository of an EU AIF has to be established in the home member state of the fund. So if there is a fund, if I am domiciling a fund in Luxembourg, then the depository needs to be in Luxembourg. This is a rule which was subject to an exception, which lapsed in July of 2017, because until July of 2017, the depository of the fund could also be in a different member state and not necessarily in the same member state as the fund. And in fact, this is in a way one of the reforms which are being introduced, in a way reviving the previous derogation, which there was in Article 21 of the AIFMD, allowing the provision of cross-border depository services. This was a result of the Commission study, where it was noted that there were some concentrated markets lacking a competitive supply of depository services, especially in smaller countries, or in countries where the depository offering is very limited to a few players. The Commission has not considered introducing or proposing the introduction of a passport, which would then certainly allow for the cross-border provision of depository services, because at the moment this option wouldn't be feasible given the absence of EU harmonization of securities and insolvency laws. On the other hand, in one of its reports, the parliamentary rapporteur has encouraged the Commission to carry out a study about the feasibility of introducing a passport in due course. To note that this derogation or this proposal to allow for the cross-border provisioning of depository services is limited to the AIFMD and not to the UCITS directive. So moving to the last two really proposals, one relating to liquidity management tools and the last one relating to reporting requirements. So starting off with liquidity management tools. The liquidity management tools, there is a whole annex which outlines what they are basically, which is a new Annex 5 which is being introduced to the directive. And the requirement is that where a manager is managing open-ended AIFs, they must choose these liquidity management tools. They are required to choose a liquidity management tool and also reflect it in there. So there's a disclosure requirement in the documentation, which is distributed to investors, and there is also a proposal for ESMA to have the power to require a fund manager. This is the proposal of the Commission, to activate or deactivate a liquidity management tool in particular circumstances. There are 8 of these tools, which are listed in the proposed suggested Annex 5 of the directive. And if one looks through them all, I think in the years that I've been practicing, I've seen them all, other than number 5 in my case at least, which is swing pricing, because all the others, be it suspension of redemptions and subscriptions, the introduction of redemption gates, the introduction of notice periods where one has to give advance notice to the fund manager that an investor is redeeming his shares, the imposition of redemption fees in case of redemptions, an anti-dilution levy where you have a levy to pay, where there is a levy which is charged where an investor is redeeming his investment, and by this redemption then prejudicing potentially remaining investors, which then introduces costs which are associated with the purchases or sales of assets because of large inflows or outflows. So a single main investor might be required to pay a levy if they decide to redeem, because then the total expense ratio would obviously increase because less investors remain, and the fund might even suffer a squeeze on the liquidation of its assets in order to satisfy that redemption request. Redemptions in kind, so this is number 7. Redemptions in kind, I think, are used frequently in the fund industry, particularly where the underlying investments are illiquid. So rather than liquidating a piece of immovable property in which the fund might have invested at an undervalue in a fire sale, there is an agreement which is reached between investors and the fund in order for these investors to actually be given either the whole or a portion of that immovable property, depending, of course, on the investment strategy and the manner in which the fund's investments are structured. And finally, side pockets. Again, side pockets, I believe the first time I saw them was in 2008, at the beginning of the financial crisis, where at the time I remember the MFSA had introduced as well rules in relation to side pockets and how disclosure should be made on side pockets. Side pockets would allow illiquid investments to be parked, not to be considered in the calculation of the net asset value. So they are separated in a pocket on the side from remaining liquid investments in order not to contaminate the whole portfolio of the fund. So the fund manager would be allowed to set aside in a side pocket these illiquid investments. And these are, I mean, these tools have been utilized by the fund industry for several years now. So no surprises here. It seems, however, that in some member states, perhaps there were a number of instances where these tools were not being utilized as they should have. I don't know about that. Finally, and this brings me really to a conclusion on the reform proposal, the reporting requirements. There are 2 types of reporting. There's the Annex 4 reporting, where it is being suggested that the reports which are today being submitted to the NCAs about investments made in principal markets of main instruments which are being managed and principal exposures, all these qualifications are removed, and basically there is a full report in relation to all markets, instruments, and exposures, rather than a qualification before each one, like main, most important, concentration. So the materiality tests in these in the current reporting, the proposal is suggesting that it is removed. Secondly, then another form of reporting where there are proposals being made is on investor disclosure. The investor disclosure requirements we've already touched upon, because these are linked really to other proposals where the fund is originating loans. So in that case, there would need to be reporting. There would need to be disclosure in the fund documentation. The information needs to be disclosed on the possibility of using liquidity management tools. List of fees and charges would need to be disclosed in connection with the operation of the fund and of the manager as well. So basically, it's further disclosure of investor to investors, which is being proposed, which to my mind sounds obvious. One last point, which I wanted to make in relation to the reform proposals relates to Article 42, which is not in the slides. So Article 42 establishes the national private placement regime. So now the proposal is suggesting the introduction of a different standard. So rather than requiring the non-EU fund manager or the non-EU fund to be established in a country which is not listed in the FATF list of high-risk jurisdictions, that is being replaced by requiring that the non-EU fund manager and the non-EU fund is not a high-risk jurisdiction pursuant to the EU's AML directive. And in addition to that, it is also proposing that there is the jurisdiction, the domicile of the fund manager or the fund is not on the EU list of non-cooperative tax jurisdictions. The rest, in relation to the signatories being signatories to the OECD Model Tax Convention, remains the same. And this is really a reflection which has already of the same, practically the same change, which has already been introduced in another directive. So similar changes were also introduced in the in other directives in the European Union, issued by the European Union. So that, I think, brings me to an end on the reform proposals. The conclusion really is that the consultation has shown that the directive has had mostly a positive impact. It has created an internal market for funds, as we were saying before. It has allowed for more effective supervisory oversight. It has generally improved investor protection as well. So really and truly, it's quite a positive initiative, which, however, requires a little bit of tweaking and some change in order to bring it in line with more recent expectations and more recent realities, which have evolved over the last 10 years. I think I've come to an end of my presentation. I can take questions if we have time, because I'm conscious that I've taken up even the question time.